So my task is to give you a review of the data protection cases coming out of the Court of Justice in the last 12 months. And obviously that is impossible because there have been so many. So I've just picked a few of my favourites to talk about today, but there is a summary of more of them in the publication. So if you want to have a quick check about whether you've missed anything, it's worth a look. So getting right down to it, first thing is we've got a couple of cases on the role of the Data Protection Authority and the limits of its discretion. And the first case confirmed that DPAs have discretion to determine whether to take formal enforcement action. And in this case, there was a data subject seeking a court order to instruct the DPA to fine their bank in relation to a data breach that had taken place. But at the point when they found out about the data breach, the bank had already reported the breach to the DPA and taken all the appropriate action to remedy the infringement. And so the DPA said, no, we don't think a fine is necessary in this case. And the court confirmed the position it had taken previously, that the DPA has discretion to decide whether to fine or not. But what's interesting is that they emphasised that this was in the context of strong enforcement of the rules, and that they might not be required to use their corrective powers exceptionally in the light of circumstances where the situation in which the GDPR was infringed has already been made good. So although it's a decision which says the DPA has discretion, I think it's also a decision which could encourage subjects in some circumstances to try and force them to take action. Then the second one is one of my favourites. It caused a brief flurry of excitement when it came out because it was about what the meaning of excessive was when it came to the right to refuse to consider complaints and requests from data subjects. And I think all of us have had a moment where we've been faced with a DSAR and thought, surely this is excessive and we can say no. Unfortunately, this was looking at the right of DPAs to refuse to look at data subject complaints. And in this case, they had said, this data subject is complaint is excessive. It noted in particular that the data subject had, within a period of approximately 20 months, sent it 77 similar complaints directed against different controllers. Furthermore, the data subject had regularly contacted the DPA by telephone in order to report additional facts and to make additional requests. So you can see why the DPA wanted to say, enough, go away. But the court said no, a high number of complaints does not on its own indicate that a data subject's complaint to a DPA is excessive. There was no suggestion here that the data subject was seeking to abuse the process or bring the DPA to a grinding halt. They were all separate data controllers. It was perfectly possible that it was 77 separate complaints. And so they could not say the complaints were excessive on that ground. So I included that partly because it was interesting and partly because it gave me a moment of personal growth, which I thought I would share with you, because first reaction when I read it was, oh my God, what a nutter. And the second was, this could be me when I retire. So I'm now looking for a hobby post-retirement when it happens to save me from being that person. The next one, I think, is the one that is perhaps of most practical use for us in the future. And it's the Dun & Bradstreet case, which looked at what constitutes meaningful information about the logic involved in automated decision-making when you get a subject access request. And in this case, the data subject had applied for a mobile phone contract costing €10 a month and been turned down on the basis of insufficient creditworthiness in the eyes of Dun & Bradstreet's decision-making system, even though they had nothing in their files suggesting that she had a bad credit record. So she asked for an explanation why. the Dun & Bradstreet was ordered to disclose this information. And there then ensued a lot of toing and froing about what was required. And in addition, could they withhold any information on the grounds it was a trade secret? And what's interesting is that the court actually said, providing a mathematical formula or algorithm, or even a step-by-step account of your automated decision-making, would not only did you not have to do that, but actually that might be unhelpful and wouldn't satisfy the requirement to give the data subject a meaningful explanation, because most of us would not understand the mathematical algorithm if we were told what it was. So you have to think about something that is clear and accessible. If you are faced with this situation, it is worth reading the case itself. It's about 3 or 4 pages where they're discussing the different levels of information that were considered and whether they were appropriate or not. Also, if you do have a situation where you think you're genuinely being required to disclose trade secrets, the process is that you should provide that information to the relevant DPA or court, and they will carry out the assessment of whether you need to disclose it or not. And move to my final slide, which is actually for the Stanley Tucci fan club, who haven't turned up tonight, unfortunately, but never mind. Very disappointed about that. This case involved the Dutch Lawn Tennis Association, and they were selling member data to sponsors for marketing purposes. And they argued that they could do this on the basis of legitimate interest. And I don't know how they've managed to do this for so long, but the Dutch Data Protection Authority has always taken a very narrow approach on legitimate interest and said you've got to find evidence for that legitimate interest based in law, and a commercial interest is not sufficient. And so they said to the Lawn Tennis Association, you can't do this. Your commercial interest is not a legitimate interest. The court disagreed. They said it could be a legitimate interest, but you do need to consider, is the processing necessary, and then balance it against the members' expectations. And this was a case for a decision for the National Court, but they made some comments about the factors that should be taken into account when carrying out that balancing test, which gave a pretty strong indication of which way they thought the court should go on that. They said you should take into account your members' expectations. Could the members perhaps have been consulted in this case? Given you have a direct relationship with your members, it should not have been difficult. And also consider the nature of the members' relationship with the commercial sponsors, one of whom was basically a national lottery and gambling company. So they might not feel it was appropriate to have their data shared with them. And so, again, it's reiterating what we know in these cases, but helpful guidance on carrying out a legitimate interest balancing test, which I think Stanley thought was quite reasonable in this case. And as I say, more cases in the publication. Thanks very much.